Well, so you don't say plans here today. Discovery issues. Nice to meet you.
Good luck.
138. Oh, Jeff. He was a carry. Work hard. Tell my friend what else is tell my friend what else is trying.
Oh, look at my little date column. It's so rude. Little plea agreement.
You play talk. Oh.
Do you know that you've been appointed to?
I do now.
Okay, will you go back to Miss Andre and know your new address? Because she is.
She actually, she just sent it to me at the time, no. So, I'm assuming this database is going to be.
Yeah, April 29th. Thank you, baby.
What happened?
Just grab a couple minutes. Okay, well, a couple minutes, couple.
I don't know what it was. I only just already had to. I want to bring my son first.
Christopher.
Down the list.
Move from number 1 to number 2.
I wasn't one.
Yeah.
Do was number one.
Padula is always number 1. Me and him fight. Sometimes he has an hour.
Back up.
On the playback?
Padula's been moved to number 5.
Yes. Because when you keep playback, you got playback over.
No. You have to hit on it.
I was on this.
Option.
Now, when we put playback, that's going to tag what you want.
Oh, it shows you today, like I can go back and back up any of the days.
If you notice, I did that.
Yeah,
Mark the
okay.
beginning. Mark the end.
Gotcha.
Once I've done that, then I'll phrase that what that's saying.
Whatever drive I want to do it
This is
to.
going to do a CD. Okay? But if you wanted to do it, just do a transfer. And then you would tell it.
Browse and pick up my drive.
Exactly. You'd go.
Okay, I'll find out real quick.
Okay. And the one thing I haven't looked up in the book, and I noticed there was a whole section on the transcription part of it. You know, the jabs, we've had their own program.
He's still ready, right?
We had the jabs that opened the program to, when we wanted to type, and listeners were typing to the recording. We don't have that with this. What's it going to be played back with on my home computer?
It actually has a video recorder that it puts with it.
That it puts with that.
So the
Okay.
transcription package has everything.
Okay.
And it almost looks identical to
What I'm
a little lighter
seeing now.
version of it.
Yeah.
Now, you may not care, but
Yeah.
you might care. What you could do, you see those 4 bars that it had?
In the playback.
It had these 4 bars.
Oh, I can change the speakers to hear.
Yes, if you wanted to mute that, so you don't want to hear, all you want to hear is whatever, you hit that and it's muted.
I got you.
That's muted.
Or I can single out
Now,
and
all
just
you
hear
hear
one
is
bar. I
chatter.
understand, okay.
And that might help you also.
Sometimes it does when they're talking over each other and I don't have it in my notes.
Because yesterday I was running into an issue where
I do. I labeled it as number 3 instead of
We
Chris.
needed to mute that.
mute that out and then I could hear it perfect.
Yeah, yeah, okay.
Now you couldn't hear it in the courtroom, you know, but you could hear it on the recording and it was really a
Interesting.
pain.
I'm sure there's going to be a few kinks to work out.
But that's pretty cool to be able to quickly just, and you will see this on the
We could
playback
do
as
that
well.
on the other.
Okay,
We could, yeah.
so if I get this all taken care of, then you have this.
I'll be sitting right here. When you got 27 pages of that, there's no way I can find and put the case into the packet case.
I can hardly read it like this.
I mean, this small section is okay, but when it goes way beyond, I mean, that's just a few pages, you know. Yeah, it's a pain.
Maybe that's all we have to do.
It just needs to be a way.
Alyssa and Mike will have a motion on that, Grisham.
To edit it.
Yeah,
It's just a motion to remove.
I believe I can give you to the edit it. And that way,
I don't know.
whatever you need to do.
Yeah, that'll help.
And then you can quickly go, okay, because you've got it.
Yeah. The only thing, the system with the other system, it was very easy to do that. Very easy to insert the tags, and I'm still working on it. I don't know why the tags would be difficult. It could be because I don't know what I'm doing. It's different. Yeah, yeah.
You only had jabs, only had the document sections over years, well, maybe 3 years ago.
But I gotta tell you, it was very easy to pick up. Just a little more complicated, but that's okay.
Everyone, please remain seated. Come to order for beginning session.
All right, Mr. Robinson, I believe because your client has taken ill, he has agreed to waive his appearance. Is that correct?
Yes, Your Honor.
Okay. All right, let's proceed then.
Believe, Your Honor, we were
Number 5.
with regard to number 5, Your Honor. I agree with Your Honor. I think everybody agrees with this premise, but as Your Honor mentioned, from time to time, matters come up and have to be handled separately. But we will adhere to that
All right.
every extent possible. With regard to number 6, Your Honor, that's Judge Osco doesn't
Right, that
apply.
doesn't apply.
Number 7, we understand that's a rule and the court's rule, and will not make any.
Well, it's not my rule, it's the state.
It's a state rule?
Yes.
Yes.
That was instituted back in the 90s during the Sunquist administration.
Okay.
I remember well because I was practicing back then.
Okay. Makes a difference. But as with respect to that rule, Your Honor, we will adhere to that. Number 8. Your Honor, I remember having a hearing regarding the young lady's text messages, and I remember Your Honor's ruling on that, and I believe, and I assume that will be the same ruling for this trial, Your Honor.
Yes, as far as I know, yes.
Just want to have that for the record.
All right.
We would adopt the same arguments. And information located in the police investigative file provided for an in-camera review. Oh, I guess that asks, really not sure what number 2 says there. Any information located in the police investigative file for an in-camera.
Please, that was asked to the incident the day before, which I don't think we want to go.
Oh, okay. I couldn't recall.
And that
All
should
right.
reflect as number 3, it should have been alleged, any alleged marijuana use, and you might not ask that question.
All right.
And regarding the marijuana use, we'll adhere to that. I know what Your Honor's ruling is. I believe we would make just on motion in limine number 8, I think the best way to preserve the record is just to ask the court if it's adopting its prior ruling with regard to motion in limine number 8.
I am.
Okay. We will adhere to that. Number 9, I don't have a copy of that in front of me. I know that's the Vanderbilt Hostess Program referenced by Coach Franklin. I don't recall that specific argument. I do recall seeing it in the transcript where questions were asked, and I do recall at least 1 or 2 witnesses called by the state when asked about the hostess program, said they were aware of it. But I don't recall Your Honor making a specific ruling on motion in limine number 9 regarding the hostess program. Because the way I see it, if I ask and they say I don't know anything about it, we move on.
Yeah, well, I don't specifically recall, but I probably did. I just, I've made 1,000 rulings since then. So
I agree.
Number 9. Well, please, I just response to that. I think Your Honor finally did rule on it after about 4 or 5 different questions, and I don't think any witness ever said there was a hostess. The issue was how do you define a hostess program. I remember Andrew E. said, well, yeah, they have men and women that show parents and students around campus like your campus does, but what they were talking about was like DAX team members and women that would take out athletes on recruiting visits. And there's a difference. People would say, well, yeah, they would host people around the campus. There was no hostess program set up. That was just a request by Coach Franklin to talk about it. It was never discussed again. She was not part of the hostess program. That was clear. She felt and, you know, it's nothing but an attempt to look at her character and say, oh, she was a hostess / whatever to football players, which wasn't true. And the question was answered by every witness. I'm not aware of a hostess program. Other couple said, well, yeah, there's a program where they take students, family that are visiting around campus and do things like that, but there's not an organized hostess program with just women and athletes, which is what they were trying to indicate had occurred, which did not exist. It was merely a question by Coach Franklin. He later found out DAX team members could not participate because they were athletes in any type of hostess program. Vandenburg quickly stopped that from happening.
all right.
Just, Your Honor, on behalf of Mr. Batey, I believe it was relevant to ask the questions. I think it was appropriate to ask the question. There were witnesses who said they were not aware of one, and there were witnesses that said, yes, I'm aware of the hostess program. And whatever weight that carries, it carries. Obviously, if they don't know anything about it, they don't know anything about it, and you move to the next question. There were not follow-up questions. There wasn't a continuous barrage of questions trying to refresh any recollection or anything like that. It was just a question.
And what's the relevance of it, Your Honor? Because you didn't know this debate. There's no relevance to whether it's a hostess program or not. It had nothing to do with Mr. Batey. It had nothing to do with her. So, I mean, why would it be relevant at all what happened that night in that dorm, whether it was a hostess program or not? If it wasn't, and to keep asking the questions, nothing to try to insinuate to the jury that she was part of some hostess program / prostitute or something. It's just improper questions.
Well,
victims of something that didn't exist.
And I think it was more directed toward Mr. Vandenburg because of they had some kind of relationship, I think. But at any rate, I really don't see any relevance in it at this juncture. I mean, all it would tend to show is something that was not necessarily proper. I mean, that would be the implication. I don't know if it's, even if they had a program, if there was anything inappropriate or improper about having such a program. But
well, the text message from Coach Franklin was, Your Honor, specifically that we're not allowed to do this, but can we do this anyway? The school won't allow us to do this, but would you be willing to assist with this anyway? So, but the hostess program questions, Your Honor, I think it is part of their life on campus, what they do on campus, interaction on campus, and I think it is relevant, and I think it's not prejudicial. I think it's prejudicial to my client if we can't ask that question. Because most of the kids were asked one question: are you aware of the hostess program? And if it was either yes or no, and everybody moved on.
okay.
And I don't understand the prejudice to anybody from that.
No relevance, Your Honor, please. There was no hostess program. And when they say, are you aware of a hostess program? And they say no, they're indicating there was a hostess program. There wasn't. And I'm not aware of any text message from Coach Franklin at all stating that. They have one. I'd like to see it. But I'm not aware of any text message like that.
And I may have spoken incorrectly, Your Honor. It may just be part of the statement she gave to Detective Mayo saying, Coach Franklin asked me to do this, said that the school won't allow it, but we want to do it anyway. And but I didn't ask her that. I didn't ask her that in court.
Okay, well, at this juncture, it's not relevant. If it becomes relevant in some kind of way, we can always have a hearing on it and see where we go from there. All right?
That's yes, Your Honor. Number 10, regarding Barbara Leal, that was stricken. Yes.
And we have number 13.
Your Honor,
Well, I don't know. You may want to speak to number 11 and 12 as well.
Your Honor, I believe we already argued number 11, which I think was whether the term victim or alleged victim must be used.
No, no.
That's 12. Number 11.
Number 11 is calling a co-defendant.
Yes, I believe we already discussed that.
All right.
And if we would not do that without a jury out of hearing first.
Okay.
I think I
So that was
already,
technically under law.
I think I already stated that.
All right. Anything further?
Number 13, Your Honor, the new number 13, with regard to number 1, I understand your court's or Your Honor's ruling with regard to number 1 and number 2. Your Honor never granted number 3, evidence or statements regarding the effect of culture on the acts committed by them. You didn't grant that, Your Honor. I don't think that was granted. I don't even recall ever seeing.
Well, I don't specifically recall. I mean, we could look back at what's what.
But
That was the defense motion number 3.
What?
Never mind. I didn't say
Well,
it.
all we're asking for the motion of limine is that it not be brought up until there's some showing of relevance. And I believe what occurred last time was that he was asked a question, I think primarily through Dr. Walker, that was dealt with
Okay.
that way. So my understanding, Dr. Walker will not be.
he is not testifying, so
Okay.
So it just asked that the motion of limine be granted, not that the court make a definitive ruling right now, but that if he wants to go into that, that we.
I understand. All right.
Thank you.
and that would be with regard to Dr. Lippman, right? So
No, I mean, it may come up with someone else.
Dr. Wilson's not going to be able to testify about any culture based on his report. He said not testing.
I agree, and I'm not saying, but that's what I'm asking for clarification on, because
Well, I think it was set forth. The state is requesting that that not come out. Obviously, if it becomes relevant at some point, then we can deal with it. And that's how motion in limine is.
yes, Your Honor.
You limit certain things, but certain other things cause these issues to be relevant, and as a result, that certain kind of testimony can come out.
Yes, Your Honor. And I believe that's all I have, Your Honor, other than to say that if we understand Your Honor's ruling, if we would like for Your Honor to reconsider one of these individual motions, we'll bring that to the court's attention.
Sure, that's fine. I'm used to hearing whatever lawyers have to say, or at least 99% of the time. Let me just mention one or two things. One in particular I'm thinking about right now. Oh, I didn't know you had something
A few
else.
more things we wanted to address, Your Honor, if you don't mind. One of them, as far as motion in limine, the defense filed a motion in limine about a certain racial statement made by the defendant during the course of the crime, and the court eventually granted that motion.
That would be allegedly made, Your Honor.
Allegedly made.
Okay.
That you granted at the time, and I'm not going to mention my opening statement, the state feels like they're seeing the last trial in the defense. If they're going to put on a defense of intoxication as to 3 counts of where the mens rea is knowing, which is an awareness standard under the law, then that's really the only alleged statement that Mr. Batey made during this is clearly attributed to him. There was a lot of different talk made, but that's a statement clearly attributed to Mr. Batey, which we feel, based on the nature of it, clearly shows an awareness, and that would be extremely relevant to show that he had a knowing mens rea of the fact that he was oriented in time and space as to what was going on in his statement. I'm not going to repeat it, obviously, but we think we may raise that later. We just want to bring that up. But now that we know, assume the intoxication defense, since it's not a defense to the first 4 counts, is being raised to try to defeat a knowing mens rea as to criminal responsibility, those things. Then his statement made during the course of this would be extremely relevant to go to his state of mind and what he was capable of observing as far as his circumstances surrounding him during the commission of this alleged crime. So we may want to revisit that. I just wanted to bring that up.
Okay, that's fine. All right.
We'll not mention it in our opening statement, but it may become relevant down the line. Also, we talked about the previous rulings, 412, Vanderbilt files. We also, Mr. Prelude, on text messages, court remembers, we had a very lengthy hearing about that, and the court excluded the majority of the text messages. I think you did allow a couple of other than that, so we just want to reiterate the court's ruling on that.
All right.
That leads me kind of into discovery. We really received no discovery in this case other than what we got, listing some potential exhibits or like anything in the world that might mention Vanderbilt, it seemed like when we looked at it. But in the last trial, several things are put up before the jury without us seeing them. We weren't provided those. A lot of times the excuse was, well, we got this from the state, which does not make the evidence relevant. So we would like to have a chance to view anything they're going to put in before the jury prior to being viewed by the jury.
Well, I mean, you have that right.
I know, and you know, it happened, and, you know, like we're going to object, like example of the naked student walking through the hall. They had no interaction with anybody involved in this case. We had a quarterback kissing his girlfriend the next morning in a dorm. Not even this dorm was put up. Things of that nature, which the state would object to, so they're totally irrelevant to this trial. A waste of time for this jury. And no reason to be put in the record. So we would just like to be privy to any of that stuff they're going to try to put up ahead of time so we can object. The court can make a ruling on relevance.
All right.
We think that might speed up the trial substantially. The only other issue I think we have is Dr. Lippman, as you're aware, had been raised earlier. I've been talking to Mr. Robinson, trying to work out some type of compromise on him. It appears we were interested whether he knew it could be on a Saturday or late Friday afternoon when he could possibly testify, which I would not think he would be engaged in another trial or teaching a class or whatever. But otherwise, if he has to be here on Tuesday, the state doesn't feel comfortable with putting him on after 2 or 3 state's witnesses, and it hadn't even come to issue yet. There's not going to be any testimony about intoxication or anything else. All of a sudden, he's going to come in with basically minimal relevance as far as the state's concerned as to 3 counts of the indictment, since intoxication is not an offense to the first 4. And highlight that, and it's going to put us behind as far as our scheduling. Witnesses flying in and out, possibly extending hotel stays and things of that nature. What we've suggested to Mr. Robinson that he come on Tuesday, and when the jury leaves after completion of testimony, that we go ahead and have his testimony in court, record it on the new technology we have, and then he can play it on the big screen TV or whatever for the jury when the appropriate time for that testimony is to come. And we'll have an example, we will have a chance to have our, if we're going to use rebuttal witnesses to review it, instead of having to be here on Tuesday. And that would give us a chance to appropriately address his testimony instead of putting, I think it would totally confuse the jury to have a couple, we'll probably be in the surveillance video by then, and bring him in out of nowhere and just set him down and start talking about alcohol testing and what he's been told about what he had to do, stuff like that. I think it would be confusion to the jury and actually would give his testimony look like special consideration just by him being stuck in the middle of the state's case like that. If it was late in the state's case and our expert was going to testify or whatever, that would work better. But I think a good compromise would be to go ahead and let him testify in court after the jury goes back, and then they can put up his testimony anytime they want to in their defense.
All right, Mr. Robinson, what do you say about that?
Well, Your Honor, I know you. Your Honor, we're in this position with Dr. Lippman because of the state's request to sever Brandon Vandenburg and move forward with trying Cory Batey's case. Dr. Lippman was scheduled to be here on the 14th. When they severed Mr. Vandenburg and asked to go to court, continue with Mr. Batey's trial, that left us scrambling just to get Dr. Lippman here. And I didn't create that issue. Dr. Lippman can be here on April 5th. I want Dr. Lippman to be live in front of the jury and not recorded. So, we're just very fortunate he's available next week at all, given the change. But again, this is part of what we're having to juggle based on Your Honor's ruling, not to give us a continuance. It's part of the strategy and trying to figure it out and get it, make it all come together. So I believe, I know the rule allows for a witness to be taken out of order. I did bring this up in Chattanooga with, I know Roger and...
Okay, rather than going back and forth on this, I'm going to see where we are at that time. If it's appropriate to allow him to testify live, that'll be fine. If it's appropriate for his recorded testimony to be taken, then I'll allow that. I'll just see where we are at that time. All right?
I understand Your Honor's ruling, but
I understand both sides, and I'm going to do what I think is best. I don't want to prejudice either side.
Yes, Your Honor. And Your Honor, with regard to sharing evidence before it's placed up on the screen, I think there was some of that going both ways. I think we got some of that from the state. I think most of those issues might have been with other counsel, not me.
Well, I know who put it up.
But George. Oh, not George.
But at the direction of a particular person.
Okay.
Anyway.
But I understand that, Your Honor. I just want to make sure that that applies to both sides. And we're willing to do that as long as that rule applies to both sides, as well as the motions in limine and what they've asked for, as long as everything applies to both sides.
Okay.
Court, please, I'll just say, General Norman is very exact and has a list right here of every video
Okay.
where it's going to be put up, and I think that was provided last time too. Obviously, they have long, and we're hoping to not go through hours of video showing nothing and argue that because something didn't click on here, I don't think Mr. Dawson's going to go there in this particular case. There was some splicing with this for some reason or something.
Okay. All right.
So it'll be short, but here this is the record.
Your Honor, I have a notice list, which is the exact, specifically named surveillance video, the exact timestamps.
Okay.
What the state's requesting is from the same thing from the defense in reciprocal discovery, that if they are planning on using a particular piece of surveillance video, that we're provided notice of it. During the last trial, random clips were put up from random...
Yeah, I see exactly what you're saying, and I don't know if they have the time to get all of that together. What I will allow is for you to view it without the jury being present, because they are under real time constraints because of the trial be starting in a couple of days. So we'll work it out, and it's what I'm saying.
We've previously filed a notice of the images based on Your Honor's ruling, because there were more images than what we're actually presenting in direct. And at the last trial, we had an issue with them using the wrong photograph. And unless they want us to ultimately introduce all of the photographs, if we could just make sure that counsel is on notice that there is a very specific listing of the images that Your Honor will permit to be submitted in this trial, and they should not be putting up any other photographs.
Right. I mean, that goes without saying. But
Your Honor, perhaps we could have a copy of this list.
Right.
I have a copy of the report as well.
Which would help, and perhaps I believe I know specifically the list, but if Ms. Norman could send me a color copy of the specific pictures again that she's referencing.
I don't think the photographs themselves are necessary. They are listed very descriptively by their exact location and file name, and I will forward them to get another copy of that list.
Okay. All right. Anything else? Okay, I said it, so I'm not going to say it again. All right. Thank you all, folks. I do have to finish my regular docket, and so have.
And we we talked about scheduling, at least how long before they run?
That's what I was going to mention when you got up. That's exactly what I was going to mention. Thanks for reminding me. We are going to go a little bit longer. We're going to go at least until 5 p.m. each day. And we may even go a few minutes after that. Say a witness is close to ending his or her testimony. We may go forward because we have a sequestered jury, and they're not going to have anything to do in the evenings anyway, so going a little bit longer won't cause them any discomfort or pain, I hope.
Yeah. Well, at least we're hoping that state will probably finish their proof on Friday morning. Hopefully that's what we're looking at.
Hopefully you'll finish it sooner than that. Hopefully.
Well, Judge, unfortunately, our victim has a final exam on Thursday that she has to take. She's going to fly in Thursday night. But I think, just based on the evidence we have, that'll probably be pretty close to the end of the trial. Obviously, we're wanting to put her on our last witness Friday morning. Don't want to interfere. Obviously, she thought she would testify a little later, too, until severance is granted. She does have that test on Thursday. She must take starting at 5 for PhDs.
And that can't be moved up in any way?
We'll check with her. I don't think it can.
I mean.
Mary cannot. This was scheduled several weeks ago. There were only two. There wasn't flexibility of when it could be. It had to be Thursday or Friday. It is scheduled for Thursday, and I mean that is the whole time that she cannot be here.
I understand, but I would request that you at least inquire one more time to see if it's at all possible that it could be moved up one day, if at all possible. I'm not saying, I obviously cannot make them do that, but let's just see if that's any kind of possibility, because there are things that I have to do as well. And I could change it, but I would hate to do so for that Saturday is what I'm talking about.
Well, and I think I absolutely will comply with the court's request to make that request, but I do think that part of it too is the preparation required for the test. But I don't think that it's possible that it can be good, but I will confirm that with the court.
They were under the same rule I was in law school. We had, my first year of law school, we had blind exams. They didn't tell us which exam we were going to take, so we had to prepare for all of them. I know it's unusual, to say the least. That rule didn't last a long time. After I think they probably stopped it after the first year, but we were the guinea pigs. And you're talking about pressure on taking exams. Try that, especially your first year of law school. So, anyway. Okay. All right. Thank you all. It's really,
All three of these I put under 5.
yeah, let me take 5 minutes so they can clear out. And then I'll finish my document.
5-minute recess.
Thank you. I know you.
Hey, let's get the staple.
Of the what?
What?
If you're going to use that to staple, that thing is not going to work. It won't. No. Last time I did that, it worked with stapler. Please don't break the stapler. I only get one.
Can you stamp all that?
So you want to come back to
Yeah, I was going to say, that is a filing.
Maybe I copy the type it.
That's a gentleman.
Hey, how's it?
What's up, Judge?
pretty good.
This one's on there.
Good job.
Amy's there.
Good job.
This one guard on the viewer.
You play ball?
What's that, my man?
What's going
That's boring. Unless it's on me.
Just showing that the item was working, right? It shows you right now that it's not. Okay. It's kind of a distraction too. So can we put that somewhere? There's, people out in the audience that's looking at us. What is that?
The blinking part?
Not the blinking part, it's just the blue itself.
I said, you know, so Debbie can.
Oh, are y'all talking? Is y'all
No.
talking? Oh. They're talking. I was trying to get Debbie to answer.
Over.
I mean, if you're gonna.
Yeah, did she not text you? I'm having surgery.
I know.
Right, no.
Yeah.
So
All's gonna be taken. Yeah, yeah.
if you move that away, you can't see it. You may think you have sound and video and not have it.
So it's more for the court reporter.
Yeah, I would definitely agree with that. But it also, if she doesn't notice it, you could also say,